Finally, and a big congratulations to the great state of Texas for finally joining the exclusive club of being one of the top asset protection states in the country. This is really, really big news, especially if you are a resident of the state of Texas, because as of September 1st, you're going to really want to rethink how you've been structuring your entities and probably now use a Texas LLC. And why is this? What is this exclusive club? Well, it's a club that consists, before this announcement happened, of basically Nevada, the state of Wyoming, the state of Delaware, and the state of Alaska. And they are the only states that extend charging order protection. It's very important. It extends charging order protection to single member LLCs. And the great state of Texas has done exactly what the other four states have done. They've rushed to their statutes. They've amended their statutes to extend the charging order protection now, not only to multi-member LLCs, but to single-member LLCs, and the charging order being the exclusive remedy, the only remedy available for creditors if they are trying to get your assets. And so why this is so important is because the charging order protection is our number one defense when we're talking about LLCs. We talked about this in several videos before, but let's do a quick recap of why charging order is so important. So remember, a charging order is when somebody obtains a judgment against you personally, unrelated to your assets or your LLC. So for example, you get into a car accident, or you run somebody over, or there's just some dispute unrelated to your assets, and there is a judgment against you. Now, what the judgment creditor, the person who has the judgment against you, would like to do is have the judge turn over your ownership in the LLC so that they could now own the LLC, they could take management of the LLC, and then obviously they could liquidate whatever's inside their LLC, your LLC, in order to satisfy their judgment. But what a charging order does is it prevents the judgment creditor from doing that and limits them to simply the distributions that you as the member would have otherwise had. So all of the distributions, instead of going to you personally, would then go to your judgment creditor until the judgment is satisfied. Now, the reason this is so important is because you will continue to retain control. And so the first thing you typically would do is stop giving yourself distributions, because why would you give yourself a distribution if that money is going to your creditor? And so it really puts you in a very strong financial position or negotiating position to negotiate something with the judgment creditor. Even though they have a judgment against you, you can typically negotiate to settle that judgment for hopefully pennies on the dollar. Now, the reason the single member is such a big issue and so important is that the reason for this charging order actually makes a ton of sense, which is if you are actually in a business with other people, let's say you have one or two other partners, then there's a public policy against having or allowing one of your creditors to come in and suddenly take over your interest, and now they're stuck doing business with that individual. So instead of wanting to continue to do the business like the business owners, now you're stuck with a third business partner who you don't even know, who just has a judgment that they have no interest in running the business and they simply want to liquidate the assets and get their judgment paid. So there's a public policy interest in not allowing the judgment creditor to get ownership of the shares, but only get whatever distributions are available so that you can then continue to run the business and not be interfered by this judgment creditor. But when it comes to single member LLCs, meaning it's just you, then that argument doesn't really hold any weight. And so a lot of courts have, over the years, started to not extend the charging order protection to single member LLCs because, again, it's just you. There are no other business partners to protect. But as I mentioned before, there are a few states, and there's actually more than 5, but now there's a few states that have extended that charging order protection not only to multi-member LLCs, which was the original intent, but also to single member LLCs. Now, there are a couple of other states that extend that protection to single members, but they don't have the charging order as the exclusive remedy, which is really important in asset protection and what we're really focused on. And that means that the only remedy available for the judgment creditor is the charging order. There are a lot of states that have that as one of the potential remedies, but maybe they can also foreclose on the interest, or there are other options available for the judge. But in the states where the exclusive remedy is the charging order, that's the only remedy that the judge can give the individual. And so this is just big news because now Texas joins Nevada, Wyoming, Delaware, and Alaska as being one of the most strongest states in the union. And again, if you're a resident of the state of Texas, I would highly recommend that you start setting up your holding companies anyway, your top level companies in the state of Texas. And if you've already got Wyoming entities or Delaware entities, you are now have a next level protection because now even if they decide to apply the laws of Nevada or Delaware, obviously you're protected there. But Texas now joins that exclusive club. So really big news, and looking forward to doing some more content at Kenny Studio regarding this Texas LLC and the new real estate strategies.